There seems to be no end in sight to TDP chief and former Chief Minister N Chandrababu Naidu's legal troubles, as hearing in 3 corruption cases are pending in the courts. Hello and welcome, I am Gitika. Let me explain the allegations and charges against Naidu in the graft cases. The APCID alleged that Naidu played the role of a principal conspirator in 370 crore skill development scam. The State Skill Development Corporation that was formed in 2014 aimed at training unemployed youth. It is claimed that Naidu approved an MOU of the skill department that violated regulations in an attempt to divert funds to private entities via shell companies. He has been charged with criminal conspiracy, cheating, forgery, causing disappearance of evidence, loss to government exchequer, and abusing his position as a public servant. Naidu had moved AP High Court following his arrest. However, the court had dismissed his petition to quash the FIR registered by APCID against him. Challenging the HC order, Naidu knocked on the door of the Supreme Court with a special leave petition to scrap the case, which will be heard on October 3rd. The ACB court, on the other hand, will be hearing Naidu's bail and CID custody petitions on October 4. Coming to the Amravati Inner Ring Road alignment case, the APCID named Naidu, former Municipal Administration Minister P. Narayana and TDP General Secretary Nara Lokesh as accused number 1, 2 and 14 respectively. The CID claimed that Naidu made changes to the alignment of the Inner Ring Road in favor of Lingamneni Estates and obtained Lingamneni Guest House as a free accommodation in return. He has been charged with criminal conspiracy, cheating, criminal breach of trust under various sections of the Prevention of Corruption Act. While the CID has filed a prisoner transit warrant against Naidu, the High Court will hear his anticipatory bail petition on October 3rd. Meanwhile, the CID has served notice on Lokesh to appear before it for questioning in Vijayawada on October 4. Speaking about the FiberNet case, the scam allegedly took place while Naidu was holding the portfolio of Energy, Infrastructure and Investment Department. The CID has accused the former Chief Minister of manipulating the tender process to allot FiberNet Phase 1 project works to a blacklisted company named Terra Software by flouting the norms. It has claimed that directors of the company were also the directors in the firm linked to Naidu's family, Heritage Foods Private Limited. Naming Naidu as an accused, the CID has filed a prisoner transit warrant in the ACB court. Naidu and Lokesh, on the other hand, filed anticipatory bail petitions in the High Court, which will be heard on October 4. To get a legal perspective on these cases, we spoke to former Advocate General of Telangana, K Ramakrishna Reddy. Listen in.
So I would like to start off asking you, there are 3 cases which are pending against Naidu. The first one relating to the Skill Development Corporation, the Amravati Inner Ring Road and the FiberNet project. How do you see, where are this case are going in the court?
See that it appears from the newspaper report the case is pertaining 2.5 years old. See, the prosecuting agency, namely CID, already registered a case 2001, have taken into custody, arrested about 36 people. There are 36 accused. Out of 36 accused, most of them, almost all, are on the bail or anticipatory bail. Now at this stage, now arresting Naidu, adding as 37 accused. But it may have some looks, there's some political overtone at this stage. So on that ground, now prosecuting agency added him as 30 accused as 37 and arrested him.
Right.
And for that, the lawyer, the Chandrababu Naidu filed a quash petition under section 482 before the Honorable High Court.
Yeah.
Honorable High Court rejected that petition.
Yeah.
Now they have already, against that order, they have already filed an appeal, SLP, before the Supreme Court.
Right.
Yeah.
So, I want to know, sir, give us a sense of what will happen if there is no relief for Naidu in Supreme Court. What is going to be the next step?
If they no, the no relief is granted to the by the Honorable Supreme Court,
Mhm,
the formally they has to wait for some time
mhm,
and to file a charge sheet against him,
mhm.
and then the process, legal process, will continue, and he has to face other, now regular bail he has to apply. That already it appears to be already regular bail has been filed.
Okay.
Probably the courts may grant regular bail.
Mhm.
If the regular bail is not granted, again they will have, the Naidu will approach the High Court and Supreme Court. That
All
is the
right.
legal process.
All right. So, for the benefit of our viewers, if you could tell us what exactly is a special leave petition which has been filed by Naidu, what exactly it is?
The special leave petition, this is the in Supreme Court, if anybody, any against any order of the High Court or judgment is filed, it is named as a special leave petition. Special leave petition, the petitioner will have no right. It is a discretionary remedy under Article 136.
Okay.
So the Supreme Court judges will go into peruse the record, the after hearing the arguments, a case file. If it is has to be admitted, they can admit it. If they wanted, the honorable court wanted to give a notice, they will give a notice. Instantly, sometimes they wanted to, the Supreme Court want to give a relief, they may say interim order, they may give. That is it is called a procedural, a special leave petition under Article 136. As per the Supreme Court rules, it is called an SLP.
All right. So the ACB Special Court will also be hearing Naidu's bail plea and the CID custody on October 4th. Will that have any sort of bearing in the case?
Naturally, because now they are not proceeding the matter,
Mhm,
because the quashing petition against the and a special leave petition is pending before the Supreme Court.
mhm.
Once it will be quashed, the whole entire accusation will go.
All right.
So there is no question of further consideration by either High Court or the concerned magistrate court
Mhm.
in respect of same case. So therefore, it appears to be that all these cases, they were adjourned for 3 days or 4 days.
Right.
Now the matter is coming on 4th October.
Yeah.
So probably on 4th October, after hearing the councils of Chandrababu Naidu and as well as Andhra Pradesh government, the court may pass appropriate order. If they feel that there is no case at all, they may they may dismiss the special leave petition. If they found any prima facie case, they may grant interim order, granting the bail to the Chandrababu Naidu
Okay.
and issue a notice to other side. Then consequently, they will file a counter, and so after some time,
Mhm.
there will be final arguments will be held and the final orders will pass. But we can't say what is that the Supreme Court will do on 4th. This is the normal procedure, what I'm saying.
Okay. And what if the case doesn't go in favor of Naidu? How long will he has to stay in the jail?
No, that normally that we can't say now, because now that suppose Supreme Court is not inclined to grant any relief in the special leave petition.
Mhm.
Naturally, he will fight with the regular bail. Regular bail, but regular bail will be given to him, because the bail petitions are pending before the appropriate courts, concerned courts.
Okay.
If that court is not granting the bail,
Mhm,
it will go again to the High Court.
mhm,
Then High Court is not considered, the matter go to Supreme Court. But I hope, because all 36 persons
mhm.
already are in the case, they are either anticipatory bail or the regular bail. So therefore, I hope that Chandrababu Naidu will get definitely a bail in that matter.
All right.
If the Supreme Court is not granted in the relief,
Right.
Supreme Court may say, sometimes Supreme Court may say, no, no, we will not interfere in this matter,
Mhm.
but we will direct the concerned court to hear the matter and to pass appropriate order, the bail, whatever applications are pending. So even by that order also will help to Chandrababu Naidu to grant the bail or enlargement or something.
All right. Sir, Naidu's counsel has argued that CID failed to follow proper procedure. Senior
Hmm.
advocate Harish Salve has pointed out that FIR was registered on December 9, 2021, whereas Naidu was added as an accused only in September 7 this year. Do you think this argument holds water?
Yes, naturally, because so the 2.5 years after 2.5 years delay, then they would have been face any prima facie case against the Naidu at that stage, all along with the 36 persons. The same government is there. They should have been taken action at that time by adding by adding the accused in the FIR, or they should have taken whatever they are taking now. But what they at this stage, I am saying after 2.5 years, because the 2024 March April elections are coming. Now another 3 to 4 months. By taking action, adding as 30 accused number 37 and arresting him is naturally it is appears to be a political overtone.
All
That
right.
there is a substance in the substance in the Salve's arguments.
Right. In fact, Naidu's counsel Siddharth Luthra has also argued that Section 17A of the Prevention of Corruption Act, where no police officer should conduct an inquiry into any offense allegedly committed by a public servant without any prior approval. So, do you think this argument has any merit in that case?
Yes, yes, because the already Supreme Court held first case in Rantule case 1988. What Supreme Court laid down the law, any minister or chief minister is a public servant within the meaning of Prevention of Corruption Act. Once he is a public servant, the prior approval of the competent authority, appointing authority is necessary to
Mhm.
protect him before taking some. Because Chandrababu Naidu, according to accusation, Chandrababu Naidu did it this all these irregularities, whatever is misappropriation, as a chief minister of the state. He influenced the officer, he planned, whatever collusion, something, they have attributed. Therefore, when he is a chief minister, now he is not a chief minister. He was at the relevant time he is a public servant.
Mhm.
So therefore, section 17A will apply.
Mhm.
But question comes the whether the argument of the other side, the state argument is the 17A cannot be applied. 17A came later.
Right.
This is prior. So it cannot be retrospectively. That what the learned judge also dealt with the matter with the High Court while in quashing petition. So my opinion, as a senior counsel, I can say it is a procedural aspect. 17A is a procedural aspect taking the prior approval of the appropriate authority. In the case of the Chandrababu Naidu, while he was chief minister, the appropriate authority is governor. So therefore, whenever the procedure, the 17A was incorporated in that, though is a later, so it will have retrospective, any procedural laws will have retrospective effect. Naturally, according to me, the 17A will apply to Chandrababu Naidu, and after taking prior approval only, they can register it, they can conduct an inquiry and other things. Now there is a debate is going on this issue, whether it is a prospective or retrospective. But in some Yashwant Sinha case, some cases were cited, the facts of the case here and there. But I feel legally it is a procedural provision. It will have retrospective effect. Therefore, that benefit can be given to the Chandrababu Naidu in respect of this present case.
All right. But sir, what I would like to point out is, though the timing and the manner in which Naidu was arrested is being questioned, uh, uh, but the allegations by the CID have not been condemned by Naidu or his team so far.
Madam, you see that suppose by condemning, they said they are what they are facing, what they are filing quash petition, another thing. You see, by accused condemning at this, denying at this stage, is may not be material because even though the accused says I did not do it, this is unnecessarily they have arrested, I was added accused. All these things will be trashed out at the time of trial. is based on the evidence, the case will be proceeded. Now, the very filing of the quash petition under Section 482 CRPC is that only on the face of the charge sheet, whatever the FIR, they have not made out any case against me. That is their argument. That itself is impliedly says he is denying the allegations.
All right. Do you
Now
think?
that High
Yeah.
Court rejected, Supreme Court may consider. It is another in another three days.
So you mean to say that CID needs to come up with more clinching evidence in order to uh, prove against the case against Naidu?
Yes, it's not only clinching evidence, there must be direct evidence. There should be a direct evidence against Naidu. He has involved that the alleged withdrawal of the amounts are misappropriated by him, or he directed the concerned authority to withdraw him. Ultimately, he has benefited that amount.
Hmm.
There must be an evidence to that. But now, surprisingly, the prosecution itself is saying the original file is missing.
Okay.
Original file is missing. That's I read in the newspaper. The original file is missing. And they can produce other evidence. But the normally these Naidu is alone is not there. 36 other accused persons are there.
Mm-hmm.
And madam, I can say the concerned IAS officers, they have come out, and persons who are connected with this matter, one IAS officer is who come in public domain, whatever they did is not correct. He is a IAS officer, he involved in this matter while taking an administration while he was in service.
Well, all right. But sir, what we are also learning is there were a few IS officers who had objected while the MOU was being signed by Naidu when the amount was released. And that was a violation. Several IS officers have opposed to that move of Naidu.
So, madam, you see that the during the process of administration, somebody will say yes, another man will say no. So, the administration process will be governed by the business rules.
Mhm.
The business rules are framed under Article 166 of the Constitution. Now, either two, the business rules are not, the Supreme Court said directory. Now, last 5 years recently, now they say the Supreme Court is say any action of the government, any administration
Mhm.
to to adhere the procedure contemplated in the business rules is mandatory. Suppose if the what prosecution is saying
Mhm.
that by signing a MOU, Chandrababu Naidu is not followed something.
Mhm.
Then if it is not followed, it will be now mandatory. It's a directly. Then directly it is a matter is in favor of the prosecution. Now all those things will come when record is produced before the court
All
and
right.
it is marked as a documentary evidence.
Mhm.
Now, whether all those actions are procedural things, whether they have adhered the business rules or not, it is a matter of investigation or the inquiry by the concerned court.
All right. So, speaking about the Amravati Inner Ring Road case, CID has accused Naidu for changing the alignment of the Inner Ring Road in favor of Lingamneni estates. Now, the CID has alleged that Naidu in return obtained Lingamneni guest house as free accommodation. Now, while the APCID has filed a prisoner transit warrant against Naidu, the High Court will be hearing his anticipatory bail petition on October 3rd. Now,
Uh,
give us a sense of where is this case going, what is going to happen in the court.
Now, madam, this is again a second case against Naidu. Like that, you can register any number of cases. A person who worked as a chief minister for a period of 5 years
Right.
after formation of the Andhra state, the several decisions has take place by Chandrababu Naidu, Chief Minister. A final approval in major policy decision, it has to be approved and accepted by the Honorable Chief Minister.
Mhm.
But in a particular case, they say you must have diverted the road, you must have taken a benefit out of the. But it is a matter of evidence whether it is a problem, whether that diversion or change of alignment is proper or in accordance with the convenience. Though
Mhm.
if he says he is according to him the alignment is changed, whether he got ulterior he has obtained any more ulterior benefit. by the whatever you are saying, the lingam and another thing. It is a matter of evidence which we cannot say at this stage. But what I am saying, even now also, madam, you say just now timing. Timing is very important. You are doing a before 4 month election. Yeah, their elections are another 4 months.
Mhm.
But that on that ground I cannot say they don't have any case.
Mhm.
The matter will go on. Normally, the bail will be granted in that case also. It's everything, whatever they are accusing against Naidu or anybody, the matter will be investigated by the court on the basis of evidence. But I am not saying at this stage that government has no case. Government has maybe case, may not be case. But it depends upon the adjudication or inquiry by the courts.
All right, all right. Thank you, sir, for sharing your legal analysis and speaking to us.
Thank you. Grateful to you.